Welcome back to Mountain West IRA's Financial Education Series. Today, we're going to talk about something that doesn't always get the attention it deserves: beneficiary designations. It may not sound exciting at first, but this is one of those areas where a single outdated form can completely change the outcome of an otherwise well-structured financial plan. In this video, we're going to cover what beneficiary designations are, when you should review them, common mistakes to be aware of, important retirement account rule changes, and practical steps for staying organized. Our goal is education. When you understand how beneficiary designations work, you're better equipped to make informed decisions. So let's begin. First, what is a beneficiary designation? This is the person or entity you name to receive assets from a specific financial account or insurance policy when you pass away. These designations are commonly attached to things like 401k plans, IRAs, 403b plans, pension plans, annuities, life insurance policies, health savings account, and even payable on death or transfer on death bank and brokerage accounts. One of the most important things to understand is this: beneficiary designations bypass probate and override your will. That means these assets pass directly to the person listed on the account form, regardless of what your will says. The financial institution follows the beneficiary form on file. This structure is designed to simplify asset transfers and avoid probate. Probate can be time-consuming and costly. Direct beneficiary transfers are often faster and much more efficient. However, when beneficiary forms are outdated or incomplete, the results may not match your current intentions. So let's talk about life events that trigger a review. In other words, when should you review your beneficiary designations? The short answer is after any major life change. Let's walk through the most common triggers. Marriage or remarriage. Marriage does not automatically update your existing beneficiary designations. If you want your new spouse listed on retirement accounts or insurance policies, you must update those forms directly with each institution. How about divorce? Divorce is one of the most critical moments for beneficiary review. Many employer-sponsored retirement plans, such as 401ks, are governed by federal law under ERISA. Under ERISA, a former spouse may remain the beneficiary unless the form is formally updated. In some states, certain accounts may automatically revoke a former spouse's beneficiary status. However, federal rules often override those state laws for employer plans. This means that if a beneficiary form was never changed after divorce, the former spouse could still be listed as the recipient. How about something more fun? The birth or adoption of a child. Welcoming a child is a major milestone and a natural time to review your plan. If you wish to include a new child or grandchild as a beneficiary, the designation must be updated. It's also important to understand that minors generally can't manage large inherited sums. In some cases, courts may appoint a guardian. In other situations, families choose to name a trust as a beneficiary, with a trustee managing funds on that child's behalf. What about the death of a named beneficiary? If a primary beneficiary passes away before you and no contingent beneficiary is named, the account may default to your estate. That can lead to probate and additional administrative steps. What are some of the other significant changes? Other circumstances that might require a review can include estrangement from a named beneficiary, a beneficiary developing a disability, significant financial changes, changes in tax laws, or blended family situations. Any meaningful shift in your personal or financial life is a reason to revisit beneficiary forms. Now, let's talk about the importance of contingent beneficiaries. Every beneficiary designation typically allows for two levels: your primary beneficiary and your contingent beneficiary. Just like it sounds, the primary beneficiary is first in line. The contingent beneficiary receives the assets only if the primary beneficiary cannot or does not receive them. One common oversight is naming only a primary beneficiary and leaving the contingent section blank. If the primary beneficiary passes away before you and no contingent is listed, the account may pass to your estate. That can reinduce probate into a process that is otherwise designed to avoid it. For many families, naming both a primary and a contingent beneficiary provides additional clarity and continuity. Let's talk about the Secure Act. Retirement accounts have unique distribution rules for beneficiaries. The Secure Act of 2019 and Secure 2.0 of 2022 significantly changed how inherited retirement accounts are handled. Under current law, most non-spouse beneficiaries must fully distribute an inherited retirement account within 10 years. This is commonly referred to as the 10-year rule. For many adult children and other non-spouse heirs, this means the entire inherited IRA must be distributed within a decade of the original account holder's death. There are exceptions known as eligible designated beneficiaries, sometimes called EDBs. These can include surviving spouses, minor children of the account holder, disabled individuals, chronically ill individuals, and beneficiaries who are not more than 10 years younger than the account owner. Let me say that again because that can be confusing. Beneficiaries who are not more than 10 years younger than the account owner. For instance, if I have a brother who is 64 and I am 59, I am not more than 10 years younger than he is. Make sense? Surviving spouses in particular often have additional options, including the ability to treat inherited funds as their own retirement account. Because retirement account distributions can carry income tax implications, beneficiary choices can influence how and when taxes are paid by your heirs. Understanding these rules is part of understanding the broader picture of retirement account planning. Let's talk about special situations. Certain family structures and planning goals require additional awareness. For instance, beneficiaries with disabilities. If a beneficiary receives means-tested government benefits such as SSI or Medicaid, receiving a direct inheritance could affect eligibility. In some situations, families use a special needs trust as the designated beneficiary. These trusts are drafted to hold assets while preserving eligibility for certain programs. Blended families. Blended families often involve multiple layers of planning. Without clear beneficiary designations, assets may transfer in ways that don't reflect the intended balance between a surviving spouse and children from a prior relationship. And then there's charitable giving. Some individuals incorporate charitable organizations into their estate plans. Naming a qualified charity as a beneficiary of a retirement account can have distinct tax characteristics because charitable organizations generally do not pay income tax on inherited retirement funds. Each of these scenarios highlights why beneficiary forms are not just administrative paperwork. They are legal instructions that determine asset transfers. So let's talk about practical review steps. In a practical framework for conducting beneficiary review, the first thing you're going to want to do is make a complete list. Identify every account that may have a beneficiary designation, including retirement plans, IRAs, life insurance policies, HSAs, annuities, bank and brokerage accounts with POD or TOD designations. You should also double check and request your current designations. How long ago did you open that account? Do you even remember who you designated as a beneficiary? Confirm what is currently on file with each institution. Many providers allow online access to beneficiary information. Then you're going to want to compare it against your current wishes. Review each account in light of your current family structure and intentions. Confirm primary and contingent beneficiaries. Ensure both levels are clearly named and up to date. Evaluate special circumstances. If your situation does involve minors, blended families, charitable goals, or beneficiaries with disabilities, additional legal planning may be relevant. And set a current review. A lot of people change the batteries in their smoke detectors every tax day because it's easy to remember. In just the same way, many individuals choose to review beneficiary designations every 3 to 5 years and immediately after major life events. So let's go ahead and wrap this up. Beneficiary designations are one of the simplest tools in financial planning. They're often just a single page form, yet they carry significant legal authority. They determine who receives retirement accounts, insurance proceeds, and certain investment assets. They operate outside of a will, and they can either simplify transitions or create complications, depending on how current they are. At Mountain West IRA, we focus on education. Understanding how beneficiary designations work helps you stay informed about how retirement assets transfer under current law. If you found this overview helpful, consider sharing it with someone who may benefit from a reminder to review their own accounts. Thank you for being part of the Mountain West IRA community, and have a great day. Bye.